Welcome to the Consumer Finance Podcast. I'm Chris Willis, the co-leader of Troutman Pepper Locke's Consumer Financial Services Regulatory Practice. And today, my partner Joe Reilly and I are going to be recapping the events of the first 2 months of the new Trump administration and talking about the current status of the CFPB, its litigation matters, and its rulemaking efforts. But before we jump into that topic, let me remind you to visit and subscribe to our blogs, TroutmanFinancialServices.com and ConsumerFinancialServicesLawMonitor.com. And if you like this podcast, you probably will like our other podcasts as well, like the FCRA Focus, all about credit reporting, the Crypto Exchange, which is about all things crypto and digital assets, our privacy and data security podcast called Unauthorized Access, Payments Pros, which is our payments-related podcast, and finally, Moving the Metal, which is our auto finance podcast. And all of those are available on all popular podcast platforms. And speaking of those platforms, if you like this podcast, let us know. Leave us a review on your podcast platform of choice and let us know how we're doing. Now, as I said today, we're going to be recapping a very action-packed first 2 months of the new Trump administration, with a particular focus on what's been going on with the CFPB, its rulemaking, and its enforcement activity. And joining me for that discussion is my partner, Joe Reilly. Joe, thanks for being on the podcast to talk with me about this today.
Of course, Chris. Thanks for having me.
So let's just jump in and I'll set the stage a little bit with the events that happened right after the administration change. So a few days after the administration changed, we had the president appointing first the Secretary of Treasury to be the acting director of the CFPB. And while he was the acting director, he essentially told all CFPB employees to kind of stop working. And then a couple of days later, the head of Office of Management and Budget, Russell Vought, was appointed as the acting director for the CFPB. And he reiterated the stop work order and also instructed employees not to come into the CFPB's offices and, in fact, for them not to do any work of any kind. Something like that was in the email to the staff. Mr. Vought also laid off all of the probationary employees of the CFPB. We understand about 200 people, and the CFPB was not really doing much at that moment. Almost immediately after all of those actions occurred, which was in the span of a pretty short period of time, just about a week, the employees union that represents the CFPB employees, the National Treasury Employees Union, filed a lawsuit in the U.S. District Court for the District of Columbia, asserting that the layoffs and the alleged shutdown of the CFPB were illegal and moved for a temporary restraining order and a preliminary injunction. A number of other plaintiffs later joined that lawsuit, various consumer advocacy organizations, et cetera, and that case then moved forward. There was also a parallel lawsuit filed, as I recall, in the District of Maryland by the city of Baltimore, which was then later joined by the attorneys general from a bunch of states, not all of them, of course, but quite a few states, again, alleging that the administration was shutting down the CFPB, and that litigation moved forward. But they've taken some pretty different paths, I have to say. So in the employees union lawsuit, the one that's pending in the District of Columbia, the parties initially agreed on a temporary restraining order while the judge could set and get briefing on a preliminary injunction motion. Then the court held a preliminary injunction hearing, then wanted an evidentiary hearing, which occurred a week later. That was on March 10th and 11th, and it went for 2 days, and then took the matter under advisement and asked the parties to submit proposed orders, but indicated during the evidentiary hearing that she was likely to issue some sort of preliminary injunction. So where that one stands right now is the TRO is still in effect by agreement of the parties, actually, and the court is considering whether to issue a preliminary injunction, and if so, whose order and modified in what way she may enter. So that's where that one stands. Joe, how about the Baltimore one? Where's that one sitting at the moment? Because that one's taken a very different course, as I recall.
Yes. I think just 2 days ago, the judge in that case refused to issue any provisional relief. The plaintiffs were claiming that the evidence that the CFPB would be returning funds to the Federal Reserve was enough of a basis for the court to intervene, but the court declined. So I think further briefing is coming in that case.
Yeah, and there was evidence submitted in the District of Columbia case that there was never any move to try to return any of the CFPB's funding to the Federal Reserve. And in fact, there was no way to actually do that even if they wanted to, was my recollection of the evidence that was presented on that point. But there was a lot of conflict in the evidence in the District of Columbia case about whether the intention was to fully shut down the agency or just to make it more, quote, streamlined and right-sized were some of the words that were used in the evidence submitted by the administration. But anyway, that's where the current litigation stands. But of course, that's not the only set of events that's been happening with the CFPB, because in addition to appointing an acting director with two different acting directors, the president also nominated Jonathan McKernan to be the director of the CFPB and submitted that nomination to the Senate for approval. Mr. McKernan had a hearing in the Senate committee as the first step of that nomination. The committee voted him out with approval, and so his nomination is now ready to be considered and voted on by the full Senate. That vote has not happened yet, but could happen at any time. And my own view is that he is likely to be confirmed. He came from the FDIC. He actually has a financial regulatory background and has experience as a financial regulator. And I don't think anything happened during his hearing that would prevent him from being confirmed by the full Senate, especially after he was approved by the committee. So that could happen at any time. And it's kind of an open question as to how that might interact with whatever the judge does in the employee union case. Because right now, the defendant is Russell Vaught because he's the acting director of the CFPB. But if Mr. McKernan is confirmed, one would think that the court will want to hear from him about what his intentions are with regard to the agency. I don't know that that will happen, but it seems like a logical thing that could occur. And it may be that that will happen while the court is still considering the preliminary injunction issue. While all that's happening, although the CFPB was sort of not doing anything after those stop work emails went out in late February, there have been some signs of the CFPB partially coming back to life and starting to engage in some work. Joe, do you want to tell the audience about that?
Sure. Some signs for sure. For one thing, the Bureau has continued to process consumer complaints as it's statutorily required to do. And then sporadically, we've been seeing signs of life in the form of emails being returned, even in some select enforcement cases. And employees who were not on official email for some time have returned, even if their future duties are unclear. I mean, certainly one of the things the CFPB has been doing during this time has been dismissing some of its higher profile enforcement actions. It's decided to dismiss 4 or 5, I think, enforcement actions that were brought by the Biden administration, but many enforcement actions are still in limbo. Clearly, there's a review going on of pending enforcement actions, and it's unclear if we're going to hear more before McKernan is confirmed or not.
Yeah, and it's interesting because even though many of the cases were dismissed, and the dismissals were with prejudice, by the way, not without, so there's no revisiting them, there's no refiling them, like they're gone forever. But the CFPB actually did make the decision to continue pursuing 2 of the pending enforcement cases and affirmatively stated that to the courts in both of those cases. So they're certainly not dismissing everything. That are, as you said, Joe, there appears to be some consideration being given to, I want to keep this one and I don't want to keep that one. But as you said, there's quite a few enforcement cases still pending, as to which the CFPB has not made a statement yet, or if it has said anything, has just said, Judge, give me 60 days to consider what I want to do, essentially. And there are a number of them sitting with stays like that, where the Bureau is supposed to get back to the court after a certain period of time. And that's going to be a familiar thing because we're going to hear about that again in a minute when we talk about rulemaking. But the other thing is that one would think that the CFPB's new leadership has to first decide what to do with those that are pending in court, the enforcement cases pending in court, because there's deadlines and schedules, and there's a judge sitting there waiting to see what the parties are going to do. But of course, the Bureau had numerous enforcement investigations underway at various stages, from initial CIDs to ones where they might have given a NORA notice or even gone further than that, but had not yet resulted in litigation. And so we would assume that there will be a similar review process for those that are not yet in litigation, but that those weren't given as high of a priority as those that were actually in court. So we'll see what happens with that, but we think that there likely will be some sort of review process there. And that's not dissimilar to what happened during the first part of Mick Mulvaney's tenure as acting director in 2017 and 2018. There was a similar enforcement review at that time, with some cases staying going and others being closed or things like that. There weren't nearly as many pending in litigation at that time, though. But the other big thing, and the thing I know the audience will definitely want to hear about, is what is the status of the CFPB's various rulemaking efforts, particularly those that were finalized during the last administration? One of the biggest ones is the 1071 rule, the small business data collection rule. And Joe, I know you're involved in that litigation representing one of the parties. Do you mind telling the audience what's going on in the litigation and the status of the rule?
Sure. So as Chris said, a number of plaintiff trade associations, including one we represent, challenged the 1071 rule under the Administrative Procedure Act. The trial court last summer actually ruled in favor of the CFPB. The district court upheld the rule, said it didn't violate the Administrative Procedure Act. We and the other plaintiff trade associations then appealed that decision to the Fifth Circuit. And in a somewhat dramatic moment on February 5th of this year, when the Fifth Circuit had scheduled oral argument, the CFPB appellate attorney, who had probably prepared to defend the rule, just like the CFPB had done in the trial court, she announced that she had received a message just that morning that in all pending litigation, CFPB attorneys were to ask for a pause and could not take any positions, and that the pause would be necessary for the new administration to formulate its position. So in front of the court, she asked for 90 days. We're about halfway through that 90-day period. And the CFPB did also agree with respect to the 1071 rule that while it's reviewing things, the rule is told. That is, the compliance dates are being put back while we wait for the CFPB. Now, in terms of a prediction, there are a couple of factors here. The 1071 is a statute. There's no getting rid of that. And the CFPB also is a party to a settlement order in a case brought by plaintiffs who were saying it was taking the CFPB too long to issue this rule. I mean, the statute was passed in 2010, so it's been 15 years. So the CFPB agreed in that settlement order to proceed with due diligence to get a final rule into effect. And the CFPB is bound by that settlement order. I think at the end of the day, where we think things will come out is that the CFPB will probably tone the rule down somewhat, which it would have to do with notice and comment rulemaking, proposing to amend the rule. I think the question about LGBTQ status is probably coming out based on other positions the administration has taken. And they may do some other things to make the rule somewhat less burdensome. But I think our prediction is that it's going to have to stick with the core of the rule.
Joe, just going back to the sort of pause or the stay on the effective date of the rule, the CFPB asked for 90 days, but that's not exactly what the Fifth Circuit did it?
Right. The 90-day period is not set forth in any order. Really, all the Fifth Circuit did was enter an order tolling the effective date of the rule. So the effective date will continue to get pushed out with every day that passes since that order from the Fifth Circuit. But I think there's still a general expectation that, and I think the court expects to hear back from the CFPB 90 days after February 5th.
Sure, that makes sense. I just thought the wording of the order was interesting because it didn't stay it for any particular period of time. It's just like, this is day by day, and we can revoke the order at any time. And by the way, this isn't a comment on the merits of the case.
Right. So we'll have to see. Hopefully, once McKernan is confirmed, the CFPB can proceed to formulate a position and inform the court.
Yeah, and then it'll be interesting to see how the plaintiffs react to that. And so let me talk about a couple of other sort of, almost every rulemaking that the CFPB had done during the Biden administration became the subject of a court challenge. And in general, in those pending court challenges, the CFPB has taken a position similar to what Joe just described with respect to the 1071 rule. And that is, court, please put everything on hold for 60 or 90 days. Let us decide what we want to do here, and then we'll come back to you. The two notable variations of that involve the overdraft rule and the credit card late fee rule. So I'd like to tell the audience a little bit about those. With regard to the overdraft rule, after the CFPB said, hey, we need to decide what we want to do with this, and it's a rule that, at least from my perspective, seemed like a pretty significant stretch in terms of the CFPB's authority, and therefore very vulnerable to a legal challenge, and therefore likely to be withdrawn by the new administration, through, again, a notice and comment rulemaking process. The court, once it got wind of the fact that the CFPB might not defend the rule, allowed some consumer advocacy groups to intervene in the case for the purpose of defending the rule, basically over the objection of all the rest of the parties, with the idea being, well, I want somebody to defend the rule, even if the CFPB is not going to. That's the only instance I'm aware of where a court has done that, but I think it's interesting. The other interesting one is the credit card late fee rule, where, again, the CFPB initially went to the court and said, give me some time to decide what I want to do under my new leadership. And the court said, okay, and stayed the case for a period of time. As that period of time was coming to a close, the Bureau filed another notice with the court saying, essentially, we have been engaged in discussions with the plaintiffs, the trade associations who had challenged the credit card late fee rulemaking, and we believe it may be possible to resolve this matter by agreement, but we need some more time to finish that process, so to speak. So give us some additional time, stay the case for an additional period of time. And within a day or so, the judge, Judge Mark Pittman, in the Northern District of Texas, said, okay, it looks like you're telling me that you may have a settlement on your hands, and so I'll give you some more time. So report back to me and tell me whether you're able to settle the case. And so that's an interesting one because it suggests that the CFPB is at least close to committing to a course of action with respect to that rulemaking that may result in the resolution of the dispute over the rule with the trade associations who are plaintiffs there, which obviously suggests that the rule will be either withdrawn or significantly modified, which again, we expected because that was a rule that we also thought was fairly out there in terms of the CFPB's authority and the basis for the rule, and therefore was vulnerable to the legal challenge to which it was subject. But it's an interesting sort of preview of what the disposition of that rule might be, and we haven't seen anything like that with respect to the other rulemakings. So I think, Joe, where are we left? What are we going to do now, in terms of having recapped these first couple of months? What do we do now?
Well, I think we wait for the McKernan nomination to be confirmed and listen very closely.
Yeah, and that's exactly what we'll be doing. I mean, I don't feel like there's any way for us to predict generally what's going to happen with the CFPB writ large. I think we can be confident that some of these rulemakings will be withdrawn or modified, but others less clear exactly what may happen to them. And certainly we need to stay tuned. And of course, we are staying tuned. We have a lot of sources of information to draw upon to know kind of what's going on with the CFPB. So we will continue to monitor it here at Troutman Pepper Locke, and we'll be reporting on events of note in our blogs and also on this podcast. So to our readers and listeners, please stay tuned to our communication channels, and we'll keep you updated as things play out in real time. So Joe, thanks for being on the podcast today. And thank you to our audience for listening in today as well. As I said, don't forget to visit and subscribe to our blogs because we have blogged extensively about a lot of these developments at consumerfinancialserviceslawmonitor.com and troutmanfinancialservices.com. And another great thing to do would be to add yourself to our Consumer Financial Services email list. You can do that through our website at troutman.com, and that will allow us to send you copies of our alerts and advisories, as well as invitations to our industry-only webinars that we put on from time to time. And of course, stay tuned for a great new episode of this podcast every Thursday afternoon. Thank you all for listening.
Copyright Troutman Pepper Locke, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman does not make any representations or warranties, expressed or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper Locke. If you have any questions, please contact us at troutman.com.